One of the more controversial laws we have is what's commonly referred to as stop and frisk laws. And this really came to light recently in a video that has since gone viral involving a blind man who was detained by the police who claimed they thought he was carrying a weapon. I'm going to break it down a little bit for you. Let's take a look.
Hi there.
Hey.
What's this in your back pocket? I just saw you walking it.
It's a navigational aid. What's the problem? You a tyrant?
Yeah, I am actually. What's your name and date of birth?
I don't have to give that unless
Yes, sir. I was investigating.
You have reasonable.
Do you want me to put you in handcuffs right now? Yes, sir, I do.
All right, so you heard him say reasonable articulated suspicion. He was so close. He didn't just pull these words out of thin air. What he meant to say was reasonable suspicion that is articulable. And what he's referring to is a landmark 1968 U.S. Supreme Court case, Terry v. Ohio. And this case laid the groundwork for what would later be known as Terry stops, or more commonly, stop and frisk. And basically what the case says, if police have reasonable suspicion that criminal activity is afoot, they can stop you and frisk you and pat you down. The reason they can do that is to ensure that you're not armed and dangerous. So the key term is reasonable suspicion. That is a very low standard. In order for the police to make an arrest, they need probable cause. If probable cause is up here, reasonable suspicion is down here. So it's very easy for police to stop and frisk you if they believe criminal activity was afoot. They just need to be able to articulate the reasons why.
What is your suspicion?
It looks like you're carrying a gun in your back pocket. I'm stopping to make sure you're carrying it properly.
Have you ensured that it's not a firearm?
All right, so almost immediately he asks her, what is your suspicion? Why am I being detained? He's forcing her to do what the law requires her to do, to be able to articulate the reason why he's being detained.
Have you ensured that it's not a firearm?
No, you keep...
All right, so he says, have you ensured it's not a firearm? She articulated the reason she stopped him, and once she's determined it's not a firearm, he should be free to leave. He's asking if she's ensured it's not a firearm so he could go. It's like he read the case law. He knows what he's talking about.
No, you keep turning so I can't see it. You don't have to be a dick to me.
Well, you're being one to me.
No, sir, I'm doing my job.
Am I detained?
Yeah, you are. What's your name and date of birth?
All right, again, so he is using the key legal words here. Am I being detained? If he's being detained, well, there needs to be a reasonable suspicion for that detainment. He's already shown her that the walker was not a firearm. She says that's why she stopped him. He's showed her it's not. He should be free to go. She should have let him go. This is where she gets into hot water.
All right, you deserve it.
77 Whiskey Mike detained. I don't know where his wallet is.
Where's your wallet at, sir? I don't have a wallet on me.
Okay, where's your ID?
Where's your ID? In my pocket. Which pocket? You are not allowed to search me.
All right, so he says, you are not allowed to search me. Technically, he is actually correct because this is not a lawful arrest. Police are allowed to search you incident to a lawful arrest. We call it SILO, search incident to a lawful arrest. They didn't realize at the time that they were making an illegal arrest, but it was. So that search is not legal, and he said it. He said, you are not allowed to search me. All right, so what ended up happening is these cops were temporarily suspended, which I think is appropriate. I'm not sure that she knew she was wrong. She just seemed a little inexperienced to me. I'm sure she will learn from this lesson. He wasn't the friendliest person either, so, these things happen, but you learn from them. I'm sure the cop will learn from them, and whoever this guy is, he knows his stuff.